So we're going to start off with Victoria N. in Ann Arbor. And she is talking about foreclosures from the foreclosure days in 2009. So from the foreclosure days of yore, we're going back here with Victoria. So she says, I have a certified forensic audit of a foreclosure that occurred in 2009. I had it done in 2015. According to the audit, it seems that there was some unusual behavior by my bank when they did the foreclosure. I think I want to bring a lawsuit against my bank. I have another home now, but the home they attempted to foreclose on had significant equity. What do you think? So from the sounds of this question,
wow, that is they're always loaded questions.
Yeah, was Victoria's home in this question in 2009? It was her residence that was foreclosed on? Okay.
Right, sounds like it. You know, I have, we have 3 law clerks at my office and several paralegals, and they assemble these questions. And sometimes I think that they just like to, you know, they're, especially the law clerks, they're in law school. And so every question is like, is a loaded question because they're great for law school essays, right? Because you can write on them forever. And I tell them, find me the shorter, the shorter answers, or the questions that require a shorter answer. It's a loaded question again, but there's a couple things. First, in general, Veronica or Victoria?
Victoria.
Oh, Victoria, okay. So first thing, just generally speaking, when somebody loses a home to foreclosure and the home goes to sheriff's sale, the time to defend or to dispute that foreclosure is between the day that you lose it to sheriff's sale, that means it's gone to sheriff's sale, and the last day of redemption.
Yeah.
So in Michigan, you have a 6-month period, with certain exceptions, you have a 6-month period to redeem the property, okay? That means to get your property back. So if it goes to sheriff's sale, you get a figure as to what you need to pay the bank back in full, and you can get that property back. Now, the Sixth Circuit Court of Appeals, which is a federal court of appeals, has said that if you as a homeowner are disenfranchised from your home because of a foreclosure, you can only challenge the foreclosure process or the procedures during that time. Okay.
Okay.
You can't go beyond the redemption period. So in your redemption period, you can file an action against the bank, but the day after the redemption expires, you don't have anything. You don't have any further standing, is what we call it, because the mortgage has actually been extinguished. So the court's reason that if there's no more mortgage, it's been extinguished. That means you can't bring anything. There's nothing there to talk about anymore. So she had 6 months to bring her case, and it's from the day that it went to sale, okay, sheriff's sale, to the last day of redemption. Now, some homes and some properties have a year redemption. There are certain exceptions for those, and we can get into those later, but long and short of it is, you would have a year if you had the exception. She says that she got, again, here we are with this like huge law school type essay, but she says that she got a forensic audit, she called it. Okay. You know what, there's a legal word for these. It said certified forensic audit, she calls it.
Sure, that's what she says, yep. So
what that is that somebody, usually the homeowner or an accountant will say, what happened here with this foreclosure? And an audit is just somebody looking to see if the process was followed properly, okay? Most companies that do these, they're out of Florida or California. They're somewhat suspect. To say there's no such thing as a certified audit.
Okay.
Okay, that's number one. It's a bunch of hooey. Okay, I know that's a legal term, but it does serve a purpose though. There's a couple I know. There's one guy out of Florida who does a really nice job. Usually they're not attorneys, they're title companies, and they just trace back what the assignment is and how things are held. That's all it is. I hope they didn't pay a lot for it. I'd like to, here's one more thing, of course. She said that she had the audit done in 2015.
Yep.
Okay, so I already talked about the redemption period expiring. right? Back in 2009 or 2010.
Yep.
And it's now 2020.
Yes.
Unless there is something that nobody would have seen before, like a fraudulent item. Fraud cases, you have 6 years to bring an action. But the question is not, was there fraud? It's when should you have found out there was fraud?
Sure.
So a reasonable person, the argument would be, okay, let's say there's fraud there. Let's say the bank did something wrong. When should the action be brought? It's not 6 years, within 6 years from 2015. It's really 6 years from 2009.
Right. Yep. So she's
Doesn't that
waited
make
11.
sense?
It's 11 years later.
Yeah, there's nothing here.
Right.
I feel so badly for this lady, but she was sold a bill of goods probably from the financial audit or the foreclosure audit. All you have to do, people who are listening, if you have a question about whether or not there was a fair foreclosure or if something was done properly, go to a real estate attorney who deals with foreclosures, a default loan servicing company, a law firm. Like myself, we do these. We review them. So and these firms cannot provide legal advice.
So her question seems to be surrounding the fact that the home they attempted to foreclose on had significant equity.
Right.
What is the significance of that in this? Like, why would that be?
I think what she's trying to say, I mean, I'm glad that you bring that up. She's trying to say that she was defrauded. I'm not saying that she's, making any misstatements. It was her home, so we have to be very empathetic. It's just that there was a lot of equity there, so I think she's trying to allude to the fact that perhaps the bank was trying to get the property back because there was so much equity. But here's the thing. I lived through 2009 in the real estate business as an attorney in the default loan servicing departments for several banks. And there wasn't a lot of equity out there for people.
Right.
So I don't think that was the motivator, although, you'd have to, then it's more than forensic. You'd have to go back to that year and then get an appraisal and see how much she actually owed on the property.
Yes.
It's a lot. These are loaded questions. I got to talk to the law clerks and say, hey, you guys got to, pare it back a little bit. But in general, the time to bring an action is during that 6-month redemption period. That's it. And then the time to bring an action because you think you were defrauded is within a 6-year period when a reasonable person would have found possible fraud.
Yep.
2015 is way too late, unless it's something completely, it was hidden so well.
Yeah, but it just makes me wonder, equity of the home when, in 2009 or in 2015, there's a huge difference there, and it's not even just the reasonable amount of equity that would accrue in 6 years. It's like it's exponential